Right, well, it's 11 o'clock and we've got quite a lot to get through, so I'll make a start now. And obviously, if anyone joins
Sure,
us, then,
absolutely.
then that's great.
Yeah, let's go.
Okay, well, good morning to you all. Very warm welcome. Thank you very much for joining us today. We're really excited about our webinar today. As you know, it's about managing ill health and absence issues in 2021. Now, if you're someone with responsibility for dealing with HR issues, you'll know that ill health can be some of the trickiest issues to deal with. And in 2021, of course, as well as the usual challenges, you've also got the effect of the pandemic, the issues about remote working and long COVID and various other things as well, just adds to the difficulties in dealing with these kind of problems. So we thought it'd be useful to have an event to run through the key things that employers need to know, and also give you an opportunity to ask questions, not only of me as an employment lawyer, but also our guest speaker, Dr. Tarek, who is an occupational health specialist. Just a few housekeeping things before we start. The session is due to last until 12 o'clock today, but because it's an interactive session, we're slightly flexible on timings. We want to give you an opportunity to ask lots of questions. If you do have a question, please could you put it in the Q&A box rather than the chat box, and that way me and Tarek will be able to see those and we'll answer as many of them as we can. And also just to mention, I'm sure you'll appreciate this anyway, but any answers we give today can only be generic, and you should always take specific medical or legal advice on the particular situation that you're dealing with at any time. Okay, to start by introducing our speakers. Obviously, many of you know me already, but for those of you who don't, my name is Nicola Brown. I'm a partner and co-founder at Pure Employment Law Solicitors, and we are a specialist law firm advising employers and employees on all aspects of employment law. When it comes to ill health situations, I can help employers with all kinds of different ill health issues, including developing policies and contracts, advising on day-to-day issues, right through to helping negotiate settlements where required, and representing in tribunal claims if that becomes necessary. I'm delighted to introduce to you today our guest speaker, Dr. Tarek Abdel-Raheem Aly, who is an occupational physician and clinical director of Prospérité Occupational Health. Tarek is an experienced occupational physician. He has extensive expertise in the provision of a wide range of occupational health services to organisations from all sectors across the UK. He's also an expert in the management of complex cases that other occupational health providers are unable to tackle. So I wanted to start today by running through some of the key things from an employment law point of view that employers need to think about when managing ill health issues as I see them. And Tarek's then going to talk about the most important things from his perspective. So first of all, when you're looking at sickness absence from an employment law point of view, the starting point would normally be the contract. And it's important to think about what rules there are about notification of absence. So regardless of the reason, you should have some contractual provisions in there telling employees how they need to notify the people of their absence, whether that's their manager or someone else in the company. And what happens if they don't. It could be a disciplinary matter, for example, depending on the circumstances. So that's certainly one of the first things you need to consider. Employees who are eligible, and that's mostly people above the national insurance lower earnings limit, will be eligible for statutory sick pay. And many people, of course, will know that that's the sort of basic statutory sick pay requirement, applies after 4 days and goes up to 28 weeks. The amount varies every year, but obviously, as we've known from the news regarding the COVID situation, it's not very generous. And some people have thought that perhaps it doesn't encourage people to take the time off that they need when they're ill, particularly when they might be contagious with something like COVID. Many employers offer additional company sick pay, either on a discretionary or contractual basis. And obviously, whatever you offer needs to be clearly set out in the contract. If you do offer discretionary sick pay, then it's important that any discretion is exercised fairly so that you make sure that you don't get accused of discrimination, for example. And that's an area where I have seen employers fall foul in the past. You can also have sickness policies that can cover things like the trigger points when people will be considered to be invited to perhaps a hearing to discuss their level of absence, particularly short-term absence, as we'll discuss in a moment. But your policies can help to build around the contractual provisions and set out the way that you as an organisation will handle sickness issues. One of the things that's really important from an employment law point of view is the difference between short-term and long-term absences. So it may sound obvious, a short-term absence versus a long-term absence. But of course, as with anything involving human beings, there are plenty of grey areas, and sometimes you can get repeated absences which might be seen as long-term but aren't necessarily quite short-term either. So if in doubt, then it's always best to take advice. But the way the law works tends to divide into two neat categories, whereas of course, as I say, sometimes things fall slightly between the two. With either short-term or long-term absence, one of the key things to bear in mind is disability. And I know that Tarek's going to be talking about this in a little while as well. So the definition of disability is set out in the Equality Act, and there are these key ingredients for this definition. It's important to mention, sometimes people think that disability is relating to things like the blue badge. Not the case at all. The definition in the Equality Act is quite different. And sometimes people who've got a blue badge will automatically, obviously, be defined as disabled under the Act, but that's not necessarily the case. So it's always important to consider that the definitions are different. So the Equality Act definition is an impairment that could be physical or mental. That impairment has to have a substantial effect on the individual. And so that's more than trivial. It has to have a long-term effect. So the definition means that it's either going to last for 12 months or more, or is likely to, or it has lasted for 12 months or more. And the effect has to be on their normal day-to-day activities. Now, this is something that employers often find tricky because they don't see their employee necessarily doing their normal day-to-day activities. They see them trying to do their role. And that's not the test. The test isn't the effect on their ability to do their role. It's the effect on their normal day-to-day activities. Now, as I've said here, strictly speaking, this is a legal rather than a medical decision. So ultimately, the person who decides whether someone meets the definition of disability will be a tribunal panel, the people who'd make that decision. But of course, they are informed by medical advice, 9 times out of 10 anyway. So that's the way the definition of disability works. Now, if somebody does meet that definition, they're protected against disability discrimination, and there's various different forms that can take. It's really important to note that there is no minimum period of service required. And once someone has met the definition of disability, there is a duty on the employer, a statutory duty to make reasonable adjustments for that employee or worker. And Tarek's going to talk about what that involves in his part of the presentation. The disability discrimination claim has no cap on the compensation. So whereas with things like unfair dismissal, there is a maximum amount that somebody can claim, in most cases anyway, with discrimination of any kind, including disability, there is no maximum on the compensation, and compensation can include injury to feelings and personal injury, as well as loss of earnings. Now, I mentioned that there were these two categories from an employment law point of view of short-term and long-term absences. Now, as I say, there are some cases that fall between the two, but for these purposes, just to look at the two different types in the main. If somebody has excessive short-term absence, eventually that's potentially a fair reason to dismiss them. And sometimes people don't realise that you could dismiss someone for excessive short-term absence, even if it's genuine. So if someone could be potentially very unlucky and just have a series of unfortunate incidents, perhaps lots of tummy bugs or something that causes occasional illnesses, but there's no sort of overarching condition or long-term pattern to them. Even if those are entirely genuine, the employer could dismiss for those absences, provided that the right process has been followed. Some employers operate a system where there are various thresholds for warnings. So you have the employee has a certain number of absences, they get given a first warning, those absences continue over a further period, there's a second warning, and then they carry on and the person ends up getting dismissed. If you do have set thresholds, for example, the Bradford factor, then those should only be used as a guide. Now, for those of you who haven't come across the Bradford factor before, I expect some of you have, but just to make it clear, the Bradford factor is calculated using a formula S squared multiplied by D equals B. So S is the total number of separate instances of absence that the individual has had. D is the total number of days of absence that the person has had, and B is the Bradford factor score. So the way that then works is it generates a figure, and some employers have used that figure to decide whether someone meets the threshold to be taken to the next stage of the warning. Anything that you use like that, whether it's the Bradford factor or any other gauge that you might apply, should always be used as a sort of starting point for a human being to make a decision as to whether the process should be followed. It shouldn't be an automatic thing, because you need to always take into account what the absences are for, whether there's any overarching condition. Perhaps someone might be going through some personal problems. There might be other factors behind it. So hopefully you'll glean that kind of information from conducting your return to work interviews, and that sort of human picture needs to be taken into account when you're looking at progressing these things. You need to always consider individual circumstances and look at reasonable adjustments. Now, we've just been talking about the definition of disability. Short-term absences could be disability related. So, for example, if someone's got multiple sclerosis or something like that, they may have bad days and good days. And on the bad days, it might be that they need to take time off work sometimes, in which case giving them a warning to improve their absence is not necessarily going to be the right approach. If there is a overarching health condition or disability, then it's best to take some medical advice, and hopefully it goes without saying, but the individual would need to consent to that medical advice being sought. Sometimes people ask me, what happens if someone doesn't consent? And if that's the case, then I always suggest that you make clear to the employee, if you don't consent, that we're only able to judge this situation based on the information that we've got, and we think it's in everyone's interest that you consent so that we have a complete picture before we make any decisions. It's quite rare for someone to refuse their consent, but some people are understandably concerned about what that might involve, so it's best to sort of talk them through it if they are worried about it. Then when you're managing long-term absence, clearly if somebody's got a long-term health condition that's meaning that they're off work, there's no point giving them a warning, because that's not going to help them come back. It's not going to, most of the time people want to be back at work. So warnings are definitely not appropriate in a long-term situation. Whereas with short-term absences, medical advice can be necessary. I think particularly with long-term absence, it's nearly always going to be required, because you need to know more about the employee's condition and prognosis in order to plan for what might happen, look at reasonable adjustments, and consider whether this is potentially going to be a dismissal situation, although subject to whatever that advice might say. From a legal point of view, you need to consider things like permanent health insurance. So if somebody has a permanent health insurance policy through your organisation, then it would be potentially very expensive if you were to dismiss them and deprive them of their right to qualify for the benefits under that policy. So certainly if you've got anybody who's covered by PHI, it's best to take some legal advice before you start looking at taking any action in regard to their absence. It's also worth considering whether they might have the option of taking early retirement, and medical advice can be really helpful in looking at whether they might meet the relevant criteria under the pension scheme for those. I've mentioned reasonable adjustments already, but yes, the medical advice is really important for looking at what adjustments might be considered reasonable. But of course, it's important to talk to the employee as well, because they may have their own suggestions. And sometimes there may be specialist organisations relating to the particular medical condition that might help you to look at adjustments and how you might be able to adapt the workplace if necessary. Whenever you're dealing with long-term absence and any employee issue, really, it's always important to adopt a fair procedure. And if you've got somebody who has reached the end of the line, the medical advice is saying that they're not likely to be fit to return for the foreseeable future, it's still important that you make sure they have the opportunity to comment before any decision is made. And I'd also recommend that you give them a right of appeal by the time you get to that point as well. Okay, that's my whistle-stop tour of the key employment law issues to think about. I'm going to hand over to Tarek, who's going to tell you about his key things that he needs you to bear in mind from an occupational health point of view.
Thank you so much, Nicola. First of all, I'd like to thank you again for your efforts in organising this event, and for inviting me over, and for the lovely introduction. And thank you so much, everybody, for taking the time to attend and join us this morning. I'm going to obviously cover a few topics that may be of interest to a lot of you. And these are things that I frequently encounter in my clinical practice from my experience with my clients. I'm going to try and be as quick as I can so as to give you all a chance later to participate in our interactive session where we could, cover any questions that you may have. Okay, so first of all, I'm going to pick up where Nicola left in terms of the Equality Act. Nicola has already provided an elaborate description of what is and isn't likely to be covered under, considered as a disability under the remit of the Equality Act. So I'm just going to pick up there. She mentioned something very important. She mentioned that ultimately, of course, it is a legal decision, but it's always important to seek legal advice. It's always important to seek medical advice to get a preliminary opinion of whether or not somebody is likely to be considered as having a disability, so that you as an organization can make the necessary decisions in terms of reasonable adjustments and support. One of the things that I always advise my client organizations is don't automatically assume that somebody suffering with any condition is likely to be considered as disabled for the reasons that Nicola has already elaborately described. It has to be long-term. It has to have a significant impact, not on their work, but on their ability to perform their activities of daily living. Always, if you're in doubt, always seek advice from occupational health. I'm going to give you a few examples from practice. The scenarios that I have seen a lot, which may create confusion, are in terms of mental health. Okay, so just to give you an example, if somebody is suffering from a condition, say for example, like paranoid schizophrenia, they are highly likely to be covered by the Equality Act in terms of disability, because this is somebody who they've got a severe mental illness. If they, for example, are not receiving the adequate levels of care, or if they're not receiving medication, they won't be able to function in daily life. Same applies if somebody, for example, is suffering from severe bipolar disorder, whereby they're, again, they will have long periods of severe depression, alternating with periods of, severe elation bordering on mania or hypomania. Okay, so these are the extreme examples that are likely to be covered, or these are the people who are likely to be considered as disabled for the purposes of the Equality Act. But these are not commonly encountered scenarios in practice. What we usually get, or what the employing organization usually gets, is, say, things like anxiety and depression. Anxiety/depression related symptoms. This is the commonest scenario. Now, anxiety and depression related symptoms, they fall into a wide spectrum in terms of severity of the symptoms. So it could vary greatly from one person to another. Some people will be on the lighter side of the spectrum of intensity, whereas other people will be on the really intense side of symptom severity. And so basically, the ones who are on the lighter side of severity, they're highly unlikely to be considered as disabled, whereas the ones that are on the severe side of the scale, they're the ones who are likely to be disabled. And again, what we do in terms, what do I personally do as an occupational health doctor, is I get, obviously, in addition to the examination, examining the person, finding out, what their mood is, their anxiety levels are, I always take detailed history. And the detailed history serves to help me to make an informed advisory recommendation to the employing organization as to whether or not they're likely to be considered as disabled. I mean, just to give you a few examples, I look for history of being, for example, under the care of a consultant psychiatrist. I look for history of being in and out of, for example, obviously history of self-harm, history of what kind of medication they're on, more importantly, and what size of dosage it is. So for example, there's a difference between somebody needing a small dosage of antidepressant daily and somebody needing several types of medication simultaneously to be able to function. So I always look at these points and I scrutinize them very carefully in order to make an informed recommendation as to whether or not somebody is likely to be covered by the Equality Act. So again, general rule: when in doubt, do not automatically assume that anybody is disabled, especially I'm giving you the examples of anxiety and depression. Always consult occupational health. Next slide, please, Nicola. Thank you so much. The second question, so as Nicola stated earlier, okay, so your duty as an employing organization is to implement, and it's very important, I always say to my client organizations, it's very important to keep notes and demonstrate. So just in case, always be careful, keep notes and demonstrate your justification and your rationale for anything that you do. So your duty is to demonstrate that you've implemented all of the possible reasonable adjustments for somebody who is likely to fall within the remit of the Equality Act. And, you know, it's the question I always get from clients is, what is reasonable? Okay, so what's reasonable? How long is a piece of string? What the rule of thumb that I say to them is, at the end of the day, what a reasonable adjustment is in essence, it's going to be a sort of cost-benefit analysis, in essence. And what is deemed as reasonable or not is going to be determined by the employing organization. So it's a subjective thing that the employing organization, so nobody's going to force the organization to say, okay, do this for that. You have to be able to justify that it's reasonable or feasible at an organizational level. Now, it depends in turn on various factors such as the size, the nature of the business. So for example, what is considered as something reasonable for a major sort of bank is going to be different from a small business, a small shop, etc., etc. But as a general rule, I advise my clients to consider the following factors, usually in order: feasibility. So feasibility basically means, is the support or adjustment, and remember, it's not just an adjustment, as it doesn't have to be something you can physically do. It could be support. Support, for example, like Nicola said earlier, by allowing somebody to be absent, or allowing them time off or flexible hours to recover or attend their medical appointments if required. That is also considered as a bit of a support, and that also has to be reasonable. So feasibility is whether or not the support is possible in the first place, as in whether the organization could reasonably accommodate the adjustment or the support, as in terms of, is it possible or not? Okay. You know, say, for example, an employee asking for chauffeur-driven, you know, Rolls Royce to take them to and from work, for example, or they want you to get them a 5-star penthouse to have their office in. So this is just an extreme example. Is it possible or not? Sustainability, number 2. This is a very important factor. So what if something is possible, but how long could you sustain it as a business? A very important example: if you could accommodate somebody being absent from work for a week, for example, how long can you accommodate the length of absence on the episode, in the single episode? But catching up with what Nicola was saying earlier, how long can you accommodate repeated episodes of absence? Again, is a very important question. How long can you sustain that? Okay. Another obvious thing is profitability / affordability. As we discussed, it's in essence a cost-benefit analysis. So if an adjustment or support is going to come at a high cost to the organization or is going to be disruptive to the organization, it's going to cause a lot of problems within the organization, then it's unlikely to be considered as reasonable. Last and certainly not least, and this is something that a lot of people sometimes overlook, is the health and well-being of the employees' colleagues. At the end of the day, an employing organization has a duty of care to protect the health and well-being of all of its employees, regardless of whether or not they're likely to be covered by the remit of the Equality Act. And the famous example, or the famous scenario that I always give is, okay, let's say, for example, and I'm going to again give the example of support. Support, so it doesn't have to be an adjustment that you implement. It could be support, as in letting somebody have, be off work or having episodes of absence to recover, etc. Okay, so what if something is feasible? So you as an organization are happy to implement it. Sustainable, okay, so you're happy to, keep providing it, and it's profitable, in terms of profit, it's affordable, okay? But what if, by offering this sort of support to the employee in question, you are then negatively impacting the health and well-being of their colleagues? Then it's highly unlikely to be reasonable in this case. And an important example is, for example, the employees' colleagues who are sometimes required to chip in at the last minute to cover the employee's workload or to cover their shifts, etc., etc. They are likely to be negatively impacted by the level of support that you are offering to the employee. So you always have to remain, and obviously, as a lot of you may have seen, especially in businesses where there is shift work or there is a heavy workload that has to be shared among colleagues, this could sometimes lead to poor interpersonal relationships in the workplace, in addition to affecting the health and well-being of the employees. And this point is one of balance and consideration. So as an employing organization, don't forget that you have an equal duty of care towards everybody. The assistance that you're offering to someone cannot sort of affect anybody else negatively. Now, another very important thing that I'd like to mention, I'm going to mention that very quickly. Remember that if somebody is altering significant alterations to the work duties, the nature of the work-related duties and / all the working environment, is not likely to be considered as a reasonable adjustment. Rather, it is likely to fall within the remit of redeployment. Just to give you an example, let's say, for example, an employee's official job description entails that they are field-based. So, for example, a field-based sales rep cannot reasonably expect the employing organization to transfer them to a desk job. It falls under the remit of a full redeployment. And when it comes under the remit of redeployment, it is slightly different from a reasonable adjustment, because while reasonable adjustments are binding, as in you have to demonstrate that you've done them, redeployment is obviously at organizational discretion, as in it is something that you may or may not have the possibility to do depending on lots of different factors. So remember, there's a difference between a reasonable adjustment and redeployment. Again, remember the example of somebody, or vice versa, somebody who works in the office can't say, for example, that they don't want to do that and they want to be based on the field. That's a completely different story. Okay. Next slide, please, Nicola. This is the last topic I'm going to cover with you today, and I thought it would be just a quick, topic, but I am pretty sure that most of you will have encountered this in your everyday work. Now, fitness to attend meetings, okay? Now, first of all, there are some types of meetings, namely disciplinary meetings and grievance meetings, grievance hearings. Now, these meetings are naturally, participation in such meetings are naturally stressful for any employee, anybody. But there's a huge difference between them being stressful and between the employee's fitness to attend. Okay, so we want to make that perfectly clear. Now, the reason why I'm saying this is that you always get that scenario. So an employee who's meant to participate in a grievance hearing or a disciplinary hearing or any other kind of hearing, capability, etc., etc. But I'm giving you the two examples that are more likely to be stressful. And you get a note from their GP saying that they're not fit to participate in those proceedings, or they're not fit to attend this meeting. You don't have to necessarily do that. Always consult occupational health. And the good thing about this scenario is that, obviously Nicola will be able to provide you with more details about that, is that the law, you have the legal right to favor the opinion or to choose the opinion of your own occupational health provider or somebody that you've solicited as an independent medical advisor over that of an employee's GP. Okay, now, in occupational health, the most important, the two criteria about fitness to attend is that, well, the most important thing is that the employee is capable of understanding the nature of sort of the accusations or what's going to be discussed in the meeting. The only two conditions where somebody, so in other words, somebody not being fit to attend because they are stressed by the event is not a valid reason. And this is always the reason that you get with GP notes. This is not a valid reason. The only two reasons where they'll not be fit is if they were severely physically debilitated, as in they physically can't participate in the proceedings. For example, somebody who is bedbound with an injury, or they are an inpatient at a hospital, as in there is a physical impediment to them being able to participate, or obviously in the event that the employee is not likely to be deemed of sound mind. So, for example, if they're suffering from a psychotic mental health condition, and this is quite a big thing, if they're not deemed of sound mind, then, then there's no, nothing, there's no point in holding the proceedings, or there's no point in them participating in the proceedings. Apart from the above, basically, everybody's fit to attend. Okay, so apart from the above two criteria, everyone is fit. Again, to reiterate, if you get that note from a GP saying that an employee is not fit to participate in proceedings because they're stressful, always consult occupational health. And we will tell you whether or not they are fit to participate in the proceedings. And again, on a rule of thumb, whether an employee is present or absent from work, they are required, and Nicola has touched a bit on that in terms of their level, how long they need to maintain contact. The employee is required to remain in contact as part of their contractual obligation. They have to remain in contact with the employing organization and attend meetings of any magnitude as required by the organization's pertinent policies and procedures, including disciplinary meetings and grievance meetings. Okay. Thank you so much, Nicola. That's
I was just going to add to that, really, that it's a situation, I agree, that arises quite a lot, and sometimes you can end up in a deadlock where the employee just keeps being signed off, can't come to a disciplinary meeting, but you've got perhaps a serious issue that's needs to be addressed. And actually, I've had situations before where it's really in everybody's interests that it is addressed, and something like this is helpful to perhaps break the deadlock and enable the meeting to go ahead. The employee may find that facing the consequences isn't as bad as they thought, and at least whatever happens, it will be dealt with. Sometimes having the threat of it is worse than the thing itself.
Absolutely. So, yeah. Absolutely. 100%. And this has been my experience as well with such cases. Absolutely. Spot on.
No, great. Okay. Well, please do feel free to put any questions that you might have for Tarek or myself in the Q&A box. There were a few people who submitted questions beforehand, which is great. So we're going to start working our way through those. But if anyone has any that they'd like to raise today, then as I say, please do add them. So start with a few of those. I think the first question is probably one for you, Tarek, if that's all right.
Okay, sure.
So someone says, we have a receptionist who is currently furloughed, but who we were looking to bring back into the business after the 21st of June. She has reported that she has been suffering from long COVID, having had COVID-19 in mid-January 2021. We've left her on furlough currently, but should she still be suffering with long COVID at the point we recall her to the business, how should we manage that situation?
Okay, that's an excellent question. And this is one of the scenarios that I've personally encountered with my client organizations, especially in the most recent period, the post-lockdown period. People are coming back, to work, et cetera, et cetera. Now, long COVID is a bit tricky. Just I'm sure most of the audience of our audience today would have read about it. Long COVID is basically somebody suffers with COVID infection, and after they have recovered from the illness itself or from the virus, they suffer with this lingering level of symptoms long after the infection has subsided. Predominantly, the predominant symptom is fatigue, severe fatigue, lethargy. They just can't, function, low energy levels, etc. Now, the tricky thing with long COVID is that the government has not issued specific guidelines. So, or the NHS has not issued specific guidelines for how long COVID symptoms would last. So, for example, they say for some people it could last weeks, other people it can be months. Okay. What I tend to do, so again, this is a question. So if you've got an employee like this, refer to occupational health. I'll take the history. I'll take detailed history of the severity of the symptoms when the employee recovered. So for example, in the case of the receptionist, when the recovery happened and the recovery from the illness itself, and the change or the course of the severity of the symptoms over the past period of time. Using this information, I am then able to project or calculate or estimate a projected period of time that is required for the employee to have attained adequate levels of recovery. And this is the way I've managed most of these cases. So I give them a timeline. Okay, so I'd say, okay, for this particular employee, they're likely to be fit to consider a return to work in approximately X, 4 to 6 more weeks, for example, or 8 to 12 more weeks, depending on the case. And at the end of that period, they can commence their phased return to work in a flexible manner, starting with a smaller number of hours with gradual increments, et cetera, et cetera. So that's how I do it. I get careful history about the intensity of the symptoms and their course, and use that to project an estimated period of time required for them to recover. And touch wood, to date, it has worked. It has worked brilliantly. The only tricky, obviously, scenario, and this is something that I've encountered recently with some of my clients, is what if somebody performs safety critical work? The most particular example is driving. So I've had recently a case of a driver, this gentleman who drives, he works in a healthcare providing organization. He drives doctors and nurses to and from places in cases of emergency. A little bit of prudence would be required in that case, just because it's safety critical. With a case like this, I have to be very prudent so as to not let them, I want to make sure that they are completely symptom-free prior to declaring them fit. But anything else apart from safety critical, I do it in the manner explained earlier.
Yeah, and presumably because long COVID is still something that we're learning about.
Correct.
That will evolve as more information is gained over time. Yeah,
absolutely correct. Absolutely.
I noticed ACAS have released some guidance about long COVID in the last week or so. So that would certainly be worth looking at for anybody who's got an employee with that. Yeah. Thank you very much.
Thank you. Thanks, Nicola.
Okay, the next one is probably more one for me, but feel free to chip in, Tarek, if there's anything you want to add. It's how regularly should we contact an employee who is on long-term sick leave? I've had situations where the employee says ongoing contact causes them more stress. How should I respond? This is definitely something that we find comes up a lot.
Yes.
And there is no one size fits all. Some people think that if someone doesn't contact them, that they're just being ignored and they don't like feeling that they're being left out of the organisation. Whereas other people, the last thing they want to do is be reminded of their employer when they're trying to get well. So it's very, very difficult, and there is no sort of ideal sweet spot that hits the mark for everybody. I think you just judge it on a case-by-case basis. And I think I would always rather make gentle contact than not make any contact at all. If somebody tells you that they want less contact, then obviously you can deal with that if it happens. But I think from an employment law point of view, you're more likely to be criticised for lack of contact than you are for making contact. So judge it very carefully. But I think if in doubt, I would rather be the person who sort of gives the occasional call to find out how someone's getting on, rather than assuming that because they're off with stress, perhaps, that they don't want any contact.
Correct. That's 100% accurate, Nicola. And just to add to that, absolutely treat it on a case-by-case basis. Because I've encountered employees who say, oh, you know, they never get in touch with me, they don't care about me. And I've encountered other employees who are like, no, they're always badgering me, calling me 2 to 3 times a week and asking me, when do you reckon you're going to return? When do you reckon you're going to return? So no, Nicola's answer is 100%, you know, always treated by case basis, and it's in the manner of the contract, of the method of contact as well. So just gently get in touch with them, find out how things are. It's always in the approach to it, but by all means, contact is essential, and judge it on case basis, especially with people who are absent with stress. So absolutely.
Lovely, thank you very much. Okay, next one is definitely one that I think you'll get your teeth into, Tarek. I often find occupational health responses vague and non-committal. What shall I do to get the best out of my referral?
Okay, oh my God, that is a fantastic question. Excellent question. And I could talk about this for hours, but obviously I won't. One of the bits of universal advice that I give, obviously, you know, with referring managers, when you're sort of writing the referral letter, always ask, for starters, always ask as many questions as you want. So don't be shy, don't hold back. So in the referral letter, always pose as many questions as you want. And like, even if the question may sound trivial, no, just ask it. Okay, for example, do you think this person is going to be fit? If not, then when do you think they're going to be fit? What is the outlook? So always ask these detailed questions. The more detail you ask, the more sort of detailed answers you get. Now, in the event that you receive a report which, where it comes to the important parts, is going to be sitting on the fence, and I've heard that expression quite a lot. Don't be afraid to inquire, or don't hold back. Inquire. Contact the clinician, the doctor who has done the, and say, sorry, I just want a bit of clarification on this. Yes or no? Really, do not ever feel shy to contact them, even by email. Method is contact by email. And by the way, medico-legally and ethically, once a doctor, so say for example, I've provided a report for you, I have to be available to answer any questions about this report, regardless of the time frame. So let's say, for example, a doctor provided you with a report last year. You have a right. So let's say, for example, something new turned up, or there's something about their report that you want to ask them about. You have a right to contact them at absolutely any time, requesting clarification, requesting enhancement, requesting, for example, for them to elaborate further on something or the other that's not clear. You have that right. Again, universal advice that I give to people: do not accept woolly or city on the fancy answers. Always inquire. Always feel free to inquire until you get the level of clarity that you want. So it's all about communication between you and the clinician who conducted the assessment. So number one, ask as many questions as you want. Number two, if there's something that's not clear, or you feel that they're trying to sort of avoid giving an answer, don't be afraid to challenge them on it. Say, doctor, yes or no? What do you mean by this? What do you mean by that? That's well within your right as a client or as an employing organization.
That's great. And certainly that chimes with my experience as well with the questions, because sometimes people will come to me after they've got the report, and when they've sent off to ask for the report, they've just said, can you give me a report about this individual and their fitness, or something very vague.
Yes.
And they haven't directed the occupational health physician on what particular things they want them to cover. So then
Correct.
If you get a vague report, that's because you haven't given clear instructions.
Correct.
So
Correct.
yes, I definitely agree that that's really important.
The case. Absolutely.
Okay, keep the questions coming in. I've got another one which I will take. Is an employee required to disclose a long-term illness to their employer? So the strict legal situation here is no, they're not. But, of course, there is a but. So if someone doesn't disclose a long-term illness to you, then you can't be expected to know about it, and you can't be expected to make reasonable adjustments for it. So there's also another angle to it, where if you specifically ask them in a questionnaire, perhaps at the start of their employment, to disclose whether they've got any health conditions and they choose not to, then that might be an issue that you'd need to take up with them, obviously depending on the nature of that. But in terms of the privacy, people don't have to disclose medical conditions if they don't want to. But equally, the flip side of that is they can't expect you to make allowances or adjustments for a condition that you don't know anything about. So that would be my response to that. I don't know if you've got anything to add on that, Tarek.
Absolutely, Nicola, absolutely. And I always, again, say to people, an employing organization only has a duty of care to the employee in terms of a particular condition if they know, only if they know about that condition. If they don't know and are not reasonably expected to know, then there's no duty of care. It's as simple as that.
Yes. Yeah. Absolutely. The reasonably expected to know can sometimes be a bit complex. Conditions can obviously arise gradually, and people don't necessarily get a diagnosis, a clear diagnosis straight away. Correct. But if you've got genuinely no reason to know that an employee has a health condition, then clearly you can't be expected to do anything to accommodate.
Absolutely. Absolutely.
Okay. Let's have a look, see if there's any other ones. I think you might have covered this one, Tarek, but someone said, what happens where the occupational health recommendations conflict with the advice the patient is getting from their GP? So when you mentioned that earlier, you said that the employer is entitled to prefer their advice.
Absolutely.
I think I would just say to that, obviously, from an employment law point of view, you've always got this reasonableness angle. So I think it would be important to explore the differences between the two opinions and try and get some clarity on exactly what the reasons for the differences are. It may be that because the occupational health report has been prepared obviously with specific instructions in mind, whereas a GP's usually their certificates or letters are very much aimed at supporting their patient, understandably, that might be a basis for preferring the occupational health report. But I think I'd be quite wary if there are significant differences about trying to find out what the reasons for them are before you necessarily prefer one report over the other.
Yes, absolutely. No, absolutely. And you encounter that, by the way, with sometimes you encounter it with a GP reports, in my experience, are usually very brief. Oh, yes, as for example, stress, XYZ, X number, for example, month by month, time off, etc. You may encounter that trick, for example, with a specialist report. So they might be, for example, in a specialist report or a specialist letter, there may be some differences. But like Nicola said, always sort of, study both and find out if there's any discrepancy. And always, again, don't, you could pose that question to the occupational physician, say to them, look, but, the consultant says this, or their treating specialist says that. What do you think? And you're always going to get the best informed answer at the end.
Excellent. Okay. Thank you very much. We've got new questions come in. What do we do if we cannot obtain a medical report from a doctor for somebody who's been off sick for a long time? We have received one from occupational health, but would like to receive another from the doctor. We've written to a doctor many times requesting it. The employee consented to the report. So I'm not quite sure of the reason there why somebody would need another report from the doctor. I guess that's the bit we're missing from this. But do you have any comments on that one at all, Tarek?
Yeah, I mean, I'm going to guess what the sort of the person who asked that question poses. Sometimes I get with some of my clients, they get that either prior to consulting me, for example, they say to me, look, we're having trouble for some reason obtaining the medical record of this or that employee from their GP. Some of my clients prefer to have that sort of information at hand. Now, obtaining medical records from the GP is sometimes quite a difficult task in terms of time. And I really do not mean to criticize my GP colleagues at all. I know that obviously their time is really, their workload is huge, et cetera. But yeah, responding to requests for medical records from the GPs can sometimes be a notoriously arduous task, because what you do is you send them the access to the Medical Reports Act, the consent form. Obviously, the employee has to be happy. You send them that, and then obviously it's a matter of waiting. Now, I have devised a way in which I do that. I very rarely ask for copies of people's GP records. I just provide my own opinion straight away from the start. But sometimes, in some very rare cases, let's say, for example, I mean, one of the most, important scenarios, say, for example, there is a safeguarding issue, for example, a safeguarding issue towards vulnerable populations, and you want to know very clearly the person's mental health history. If I feel that the person is withholding something from you, not being accurate, it's only in these rare occasions where I get their GP records. I've devised a way that saves a lot of time, because again, it can be notorious. And I'm talking, I mean, my record, the worst ever scenario that I've encountered is a GP who got back to me after 6 months, 6 months, 6 calendar months, to the extent that I wanted to say to him, what's the point? What is the point? But anyway, I've devised a way. Instead of using post, okay, I use encrypted email. Encrypted, password protected email. So that automatically saves you the time of that post coming and going. And it also, again, you could put a letter in the post to a GP today, but by the time they read it, so their secretarial or admin team will put it at the bottom of a pile on their desk, and they'll do a little bit each day, and that could add time. But if you send it by email, by encrypted email directed to the doctor that you need the request from, that sort of makes it more personalized. It saves you the time of transit, saves you the time of them getting to it. And most importantly, you've got a paper trail. Yes. So you've got a paper trail that you've sent. Yes, doctor, I've sent you that email on this or that date requesting the notes. Please kindly provide me with. And I've used that strategy, and it's really, really cut down the time required. So this is, yeah.
So with this particular situation, obviously, I don't know why the further report is required, but if the person has been asked to get a further report and the GP just isn't providing one, presumably sooner or later you draw the line and say, we're going to have to proceed without it.
Absolutely. Can't wait anymore. And, we have to make an informed decision now with the evidence that we've got. Absolutely.
Yes, yeah. And it's a question of when you draw that line, I suppose.
Yes.
It depends on the situation.
Yes,
yeah,
absolutely.
Okay. No, thank you for the question. This one was one that I'm personally quite interested in. So what are the key things that employers need to bear in mind from an occupational health point of view in terms of musculoskeletal issues caused by working from home?
That's for me, of course.
Yes, please. Yeah.
Okay. Yeah. That is an excellent question, by the way, and excellent. And I get that a lot. The most important thing for working, and obviously, especially with the known circumstances of a lot of people having been, redeployed to home work, either permanently or temporarily, the most important thing, in my opinion, or the most important point or the issue that I've encountered is the suitability of the furniture of their workstation. To put it in the simplest possible terms, the suitability of the furniture. Now, using video, and obviously using video consultations, I have personally been able to examine the workstation, the home-based workstation of the employee in many, many cases. So I go on video and I get them to show me around their workstation, et cetera, and based on that, I make recommendations to the employing organization. Now, so rest assured, for example, a lot of organizations may be like, okay, but, we can only, we don't want to cover, for example, expensive stuff for, and I completely agree with that. 9 times out of 10, to give you the scenario, a lot of people will use their dining table as their makeshift desk, okay? And they'll have like an unsuitable chair or even a cushion. Some people would just get a random cushion or even a stool or something, a high chair. And obviously that's not ideal. So we're talking about this can cause, number one, first and foremost, spinal problems, neck, back, lumbar, et cetera, et cetera. I examined the workstation via video, and then 9 times out of 10, my advice is, number one, so even if they're going to use the dinner table or any other kind of table, number one, a suitable office chair. It doesn't have to break the bank at all, and it doesn't have to be one of those fancy hydraulic space, ultra. No, nothing at all. All that is required is a suitable office chair, standard issue, that has a rigid back and preferably armrest and adjustable height. Okay, that's all, because using the adjuster, so that's number one, first and foremost. Number two, a laptop lifting platform. These are very, very readily and cheaply available online. You could get a very decent one for 20, 25 pounds. And using the combination, the employee can then use the combination of angles and heights of the laptop lifting platform and their office chair to achieve the maximum position of most comfort. And I give them always advice in terms of the health and safety executive advice on the DSE regulations. I give them that famous picture, back straight on the chair, arms rested, eyes 15 degrees at the most, looking at the screen, etc., and using a combination of a standard issue office chair and an adjustable height laptop lifting platform. They could always adjust the most comfortable position without breaking the bank at all. Both of these items are readily available.
No, that's really good to know. Thank you. Yes, so much simpler than perhaps some people might have envisaged.
Absolutely.
Yeah. Okay, we're coming to the end now, so I'll just see if we can fit in a few more if we can.
Sure.
You and I talked about this one the other day, Tarek, and I think this would be quite useful to cover. So if we think an employee might be exaggerating their symptoms, such as back pain or stress, can we highlight that in some way to occupational health?
That is an excellent, you obviously get that's a very excellent question, okay? And yes, it is, I understand the trick here, and the tricky thing about this, and obviously I'm gonna I'm assuming that the person who's asking the question is basically saying, there is a limit. Obviously, I completely understand to what you can. There are certain things that you can't, express formally. So let's say, for example, if you have in the referral letter, you usually put facts, fact. Sometimes there is something that you want to add, which is a bit speculative in nature, but it is important to the case. You are any good occupational health provider will give you the opportunity to confidentially convey such kind of messages to the clinician prior to the consultation. So that is the short answer. So a good occupational health provider will allow you to convey that, be it in the form of a confidential email, a remark, or even a confidential phone call prior to the consultation. I mean, in most of the complex cases that I have encountered, having a sort of getting the full picture of the case has proven to be vital. So in terms of that aspect, so no, you can, if you've got certain concerns or something that you'd like to convey in confidence to the doctor, you could ask for that. You could ask for the freedom to do that via in writing or via conversation, etc. That okay. is, you can request that.
No, that's great. No, thank you very much. Okay, well, that's been great. Thank you ever so much to everybody who submitted questions. I think we're going to start to wrap it up there. So I'd like to say a big thank you to Tarek for joining us today.
Thank you so much.
Everyone's found it useful. We're going to send through an email to everybody who's attended today with our contact details. So if you ever need to take advice about a particular situation that you're dealing with, then obviously Tarek and I will be happy to talk to you about it. If you found today useful, I'd be grateful if you could let us know. Also, I think there's one more question may have come up. Just have a look. Oh, no, it's a very kind comment saying thank you.
Oh, thank you. It's a pleasure. Thank you so much.
No, that's great. Okay, so thank you very much to everybody for attending and enjoy the rest of your day. Thank you very much.
Thank you so much. Thank you, Nicola.